Pardon? Oh, okay. All right, this would be case 2021 MM 8693. Let's see, the name is, where's the name? There. Oh, okay, right there. Pierre Joseph Maderi. We have the Creole interpreter on the line.
Yes, hello, this is the interpreter. I'm having a hard time hearing what is being said.
Okay. Have you been sworn?
No, I have not.
Please raise your right hand. Do you swear to translate from Creole to English, English to Creole, truthfully in these matters here today?
I do.
All right. And would you state your name, please?
Interpreter's name is Anne. Interpreter ID number is 200857 for Haitian Creole.
All right. And I ask the defendant to state his name, please.
S'il vous plaît, dis tout nom.
Oh, Pierre Joseph Nader.
Pierre Joseph Nader.
All right. Here on a charge of battery domestic violence, I have found probable cause. Is there any challenge to probable cause?
No argument, Your Honor.
Okay. And
I'm sorry, go ahead.
okay. Do we have the victim here?
No, Your Honor.
No. Okay. All right. What's the state's recommendation on bond?
Does the interpreter need to interpret any of
I'm
that?
sorry.
Does the interpreter need to interpret any of that?
Oh, okay. I'm asking for the state's recommendation on bond.
Your Honor, it appears that Mr. Maderi has little to no criminal history. However, given that it is a victim case, they would ask for the standard $500 that DV bond.
Okay, I'm having trouble hearing. So, what was the recommendation?
$500, Your Honor, given he has little to no history.
$500 and no contact.
No contacts, separate residences, a one-time return, and no weapons, firearms, or ammunition.
Okay, so
Your Honor,
yes.
could the interpreter interpret for the defendant?
Okay.
Okay, so what, I'm sorry, there's quite a bit that was said. I don't know where to start. What would you like me to interpret right now?
Could
Because
you
I
just
cannot paraphrase.
Could you interpret what the state attorney just said?
Okay, so, state attorney a dit que il recommandé pour yon bon, pour payer $500 bon, pour pas prendre aucun contact avec victime nan, et puis pour nous aller, n'a pas obligé rester dans l'autre cas, ou pas qu'à habiter dans même cas avec victime nan.
Bat yam wet même côté avec non depuis 2 mois, li rentre ici. Et là moi la vive là quand moi le vini, bat gen rien avec le téléphone moi le prend pam.
Okay, dans un moment.
Yeah.
I never lived in the same residence with her. She came to my home and took my phone.
All right, so you have your own residence. She does not live with you.
Ou gen propre côté pa ou habite, li pa habite ensemble avant?
Non, li habite à Papcam habite Orlando.
No, I live in Orlando and she lives in Apatka.
Your Honor, in that event, state would ask for no return, no contact, no weapons.
N'a demandé pour pas alla kaili, pour pas alla kayou, pour pas gen aucun, ou pas ka posséder aucun zam, ou pas ka prendre contact avec, ou pas ka relèl, parler avec, pour aucun contact avec du tout.
Pas posséder aucun zam, mais il vient là kay moi, pas vinn là kay li, pas non rien avec, il vient là kay moi hier matin et puis li juste en de mon relève, li prend téléphone moi et puis me prend.
Un moment, monsieur. I don't have any weapons. I don't make contact with her. She's the one who came to my home, and somebody called me on the phone, and she grabbed my phone. And
Okay, but okay, I'm going to $500 bond, no contact with the victim, either directly or indirectly, and You will maintain separate residence.
Juge la di ou que bon an c'est $500, ou pas qu'à aller prendre contact avec moun sa, pas du tout, ou pas qu'à dans même cas avec lui, ou pas qu'à posséder aucun zam. C'est l'autre juge la baye.
Do you, sir, possess any firearms?
Monsieur, est-ce que ou même ou gen aucun zam,
Pa gen ok.
zam à feu?
Depi mti moun bako, memman yon zam nan vim.
I have never touched a firearm in my life.
All right, well, I'm going to just have, no, you're not to possess any firearms.
Yeah. Ou pas supposé posséder aucun zam à feu.
Okay, all right. All right, can you post a $500 bond, sir?
Monsieur, est-ce qu'on peut payer un bon pour $500?
Mwen ka paye li sou 4 mwen li an ba, sou mba ki jam ka fe sa.
I can pay it with my card, but my card is downstairs. I don't know how to do it.
Does he qualify for pretrial release?
He did not, Your Honor.
Okay, well, $500 bond. Okay, all right. I'm sorry? Oh, I'll point to the public defender's office, yes. Okay. You need that back? Okay. Okay. I'll give you this. Okay, all right. Now, next. All right, thank you. I don't think we need a Creole interpreter. We have the Spanish interpreter on the line?
Your Honor, would you like me to transfer you so you can get a Spanish interpreter? Is that what you're asking me?
No,
just tell her she can hang up.
do what now?
The Creole can, disconnect.
Okay, she can disconnect for Creole. Okay.
Thank you. Thank you so much for using our
You're welcome. All right.
Good morning, Your Honor. This is Theodore Leal, Spanish interpreter. The interpreter has been previously sworn, Your Honor.
All right, have you been sworn in today?
Yes, Your Honor.
Okay, good. All right. This is case number 2021 CF 15649, State of Florida versus Leandro Raul Adrizola Cont. All right. The charge, attempted felony murder, aggravated battery, deadly weapon, violation of domestic violence.
Sorry, Your Honor.
Yes.
The interpreter just fell behind.
Oh, I'm sorry. Let me start over, and I'll try to go slowly. Forget. Okay. This is State of Florida versus Leandro Raul Adrizola Cont. And case number 2021 CF 15649 AO. Charges are attempted felony murder, aggravated battery with a deadly weapon, and violation of domestic violence injunction. And I do find there is probable cause. So it appears that it was out on bond on another case.
Yes, Your Honor. Given that count 1 is a first-degree felony that is punishable by life, state is asking that you hold him no bond pending an Arthur hearing.
Okay,
downtown at a later time, and to set reasonable bonds on count 2 and 3. And as a result of picking up these new law charges against these same victims, they would ask that you revoke his out on bond case, the BAT DV 21 MM 6752.
all right, so because of that probable cause of a new violation, the court will revoke that bond and set no bond. And was there a bond recommendation on the other charges?
Your Honor, state would ask for no bond on count 1, 5,000 on count 2, and 5,000 on count 3.
All right, any response by the defense?
We would ask for reasonable bond on all counts, Your Honor, if you aren't inclined. Mr. Cant is still entitled to a full Arthur hearing to set bond with his attorney downtown.
Okay, on the count 1, the court will set bond at 500,000 and was it $100 each on the other two?
500,000 on the life offense?
Pardon?
500,000 on the life offense, Your Honor?
I get, yeah, 500 on the other two. Okay, and well, yeah, 500 each. And there'll be no contact and no, let's see, do they live together?
Your Honor, state would still ask for no separate residence and a no return to the victim's
Okay,
residence.
separate residence. If may not possess any firearms or ammunition, if you have any, that must be turned into the sheriff's office if released. All right, anything else?
No, Your Honor.
Nothing from the defense, Your Honor.
All right. All right. Yes. You think you are? Okay, do we have any other cases for the Spanish interpreter? Okay. All right, call the next, or what's the next one? I'll give this to you or to them? Okay. All right, next one. Which case? All right, next case is defendant Wilfred Tomas Chunekskoy. Is that your name, sir? Would you state your name, please?
Wilfred Thomas Chungishkoi.
All right,
Wilfred Tomas Jr. Coy.
all right. You are charged with battery and assault. Court finds there to be probable cause. Let's see here. Is the victim present?
No, Your Honor. Your Honor, state would ask for 500 on each count.
Okay,
The main concern being the community ties.
all right, yeah. $100 bond, and you're to have no contact. You must maintain separate residence. If you, let's see, do they? If you need to return to the residence to obtain your physical belongings, you may do so if accompanied by law enforcement. Pardon? One time. And you are to possess no firearms or ammunition. If you he may be turned over to the sheriff's office. Find probable cause. Is there and you are not to partake of any alcohol. Point to PD, yeah. Go ahead and say, I'll point to PD in all these cases unless. Okay, all right. And anything else?
No, Your Honor.
Next.
Este es no.
Paperwork today, huh?
All right, the next case, State of Florida versus Melvin Fedraza Fonseca, Melvin. Case number 2021 MM 8715. All right, charge of battery domestic violence. We do have a victim present, I believe.
Yes, Your Honor.
Okay, all right, first of all, state your name, please, sir.
Melvin Pedraza.
All right. And, okay, would you swear in the victim? She need a Spanish interpreter too? Okay.
Interpreter, you still there?
Yes, interpreter is here.
Do it over the loudspeaker for the victim, please.
Very well.
Please raise your right hand.
La mano derecha, por favor.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Voy a decir la verdad, toda la verdad y nada más que la verdad.
Sí.
Yes.
All right, would you state your name, please? You can put your hand down.
Puede bajar la mano. Diga su nombre y apellido, por favor.
Angélica Montes Ocasio.
Angélica Montes Ocasio.
And what is your relationship with the defendant?
¿Y qué parentesco tiene usted con el acusado?
Es mi novio hace 5 años.
He's been my boyfriend for 5 years.
Okay, and he's being held on a charge of domestic battery, violence, and do you wish to have no contact, or do you want to have contact with him?
Él está aquí retenido por un cargo de violencia doméstica con agresión física. Ahora, ¿usted desea tener contacto con él o no quiere tener contacto con él?
Sí.
Yes.
Well, yes, you want contact or you don't want contact?
Dice que sí quiere contacto o que sí quiere que le quite el contacto.
Que sí quiero contacto.
Yes, that I want contact.
All right. I do find probable cause, and I'm going to say no hostile contact. Do you understand what that means, Mr. Pedraza Fonseca?
Así que voy a determinar que hay indicio de culpabilidad y voy a permitir contacto, pero sin hostilizar, sin hostilidades. Así que ¿entiende usted lo que significa contacto sin hostilidad? Yes.
Okay. All right. And what's the bond recommendation? $500?
He does qualify for PTR.
Oh, PTR. Okay, we'll do PTR release. All right.
Your Honor, subject to 907.041, that DV being a dangerous crime under Florida statutes, he can't be put on straight pretrial release. It would have to be pretrial release with bond.
I'm sorry, I didn't hear.
Subject to Florida statute 907.041, battery DV qualifies as a dangerous offense. Therefore, he cannot be on a straight non-monetary release. So if you want to put him on pretrial release, it would have to be pretrial release with a small monetary bond.
Okay, with what?
Tomando en cuenta que es una ofensa peligrosa contemplada en los estatutos de la ley de Florida, por por la ley 907.041, no se le puede dar la libertad provisional directa nada más. Tiene que ser libertad provisional con un pago de una fianza.
Your Honor, state's recommending PTR with a $100 bond.
PTR with $100
La libertad
bond.
provisional y $100 de fianza.
All right, can you pay a $100 bond?
¿Puede pagar $100 de fianza?
Okay, so that'll be granted.
Cedido.
Yes. All right, anything else?
What are the conditions with that, Your Honor?
I'm sorry?
State would ask for an addition to the no hostile that you've already placed, also no weapons, firearms, or ammunition due
Yeah,
to being
yeah.
dangerous.
And no, do you own any firearms, sir?
¿Tiene usted es dueño de algún arma de fuego, señor?
All right, you're not to possess any firearms or ammunition.
Así que también está prohibido el porte y uso de armas de fuego o municiones.
All right, thank you. All right.
Gracias.
Interpreter, we are done with our cases for the moment.
Very well.
All right, thank you.
You're welcome, Your Honor.
All right, next case is Paul Clark. No, I'm sorry, oh, he refused? Okay, then I find he waived the appearance and probable cause. Is there a bond recommendation on Paul Clark?
Your Honor, state would just ask that you stay the 250 as currently set.
Okay, let's see, did he, all right,
He recently pled also to a city ordinance case on 12/3, approximately 7 days ago. He pled to another city ordinance case similar to the one that he was charged with today, approximately 7 days ago.
if you guys are comfortable taking your mask off when you speak, that would help me understand. Okay. I'm sorry, what did you say?
State's asking that you stay the $250 bond due to him pleading 7 days ago, also to a city ordinance case.
Okay, so, okay. All right. Yeah,
Okay, you say you were funding PD on.
yes, public defender's appointed, yep. Okay, and, are you Ricardo Pagan? Okay, all right. All right, you're charged with, sir, with violation of domestic violence injunction. You find there to be probable cause of appointed a public defender. What is the state's recommendation on bond?
Your Honor, given that it is a violation of a domestic injunction and there is an injunction in place, 21 DR 13580, and it does appear that he's violated it several times with other like cases on 12/6, approximately 4 days ago, and on 11/17, approximately a month ago, also with burg dwellings. State at this time is asking for $10,000.
All right. You want to say something, sir?
Yes, I did not violate those at all. Negative right now, okay? I have no money to bond out of here.
Well, I'm not here today to determine whether you're guilty or not guilty. I just have to go by what's.
No, I just don't have money to bond out. They're doing this high bond so I can stay here until the court date. I'm in the negatives. I get SSI check. Nobody's gonna bail me out.
Well,
I need to just be released or something because I have no money to bail out. I can't afford none of that. They're screwing me over. Trust me. They want me to be in jail so they have a better case for me because all that is false. I can tell you that now. All those accusations are false.
Your Honor,
I'm the victim in this case.
respectfully, there isn't a permanent injunction against this defendant for this victim at this location. He's not supposed to be within 500 feet of this location. There are 2 independent witnesses who placed him at the scene of this location, and it has been allegedly occurred at least twice prior of him also trying to burglarize and get into the same house.
Right, doesn't he have other cases pending?
Yes, Your Honor.
All right, well, because of finding probable cause, I'll revoke bond in those cases.
I don't believe they're out on bonds in that respect, Your Honor. I believe
pardon?
they've just been arrests.
I'm sorry?
We don't have open cases currently. They've
Oh,
just
you
been
do not?
arrests.
Okay, okay. All right, well, I'm going to go with $10,000 recommendation.
10,000.
Yeah,
You want to do?
and no contact, victim, and no, if you have any firearms, you're not to possess any firearms, ammunition.
What judge
All right,
does that?
Your Honor, state would also ask for the condition of to comply with the injunction in 21 DR 13580.
okay, all right. Yes. Yeah, no. Okay. Charles Cox. Pardon? Okay, what's your name, sir?
Charles Laverne Cox.
Okay, one second here. All right, Mr. Cox, you are charged with a contempt of court violation of no contact order.
Your Honor, this case was seen yesterday. It was reset, and PC was found. It was reset for the state to find the appropriate statute. It should have been a violation of a condition of pretrial release,
Okay,
not a violation of a no contact order.
okay,
So PC was found for the violation of a condition of pretrial release, which is statute 741.29 sub 6.
okay.
Okay, can I speak also?
Okay, so there was probable cause for that. Is there a recommendation for bond?
Can I speak, ma'am?
I'm sorry?
I believe the victim says she would like to speak. Your Honor.
Oh, okay.
I would definitely like to speak, please. That's my husband. We've been together for 15.
Raise your right hand, please.
Yes,
You swear to tell the truth, the whole truth, and nothing but the truth?
yes, ma'am. That's my husband. We've been together 15
All right,
years.
state your name, please.
My name's Diane Cox.
I'm sorry?
Diane Cox.
Okay, and your relationship with the
He's
defendant?
my husband. We've been together 15 years. I bonded him out, okay? I bonded him out the day before Thanksgiving. We had no idea that there was a no contact or whatever they're calling it today, okay? So he was at my home. He was getting his bike. There was no violence. There was no argument. There was no aggression. The police officer that came didn't even know if he should. He said he had to take him, but he didn't want to take him. The clarification was coming in because whenever I was leaving for work, okay, but he was gonna stay there and work on his bike, okay? So I was appalled when he got arrested. We were both completely in shock. I mean, there was never any altercation whatsoever. Neither of us had an idea that he shouldn't be there.
All
So
right.
when he was arrested the other night, I still don't understand why he was arrested and now he's in here on a felony violation. I tried to call the state's attorney 10 times yesterday. I tried to call his public defender, Aaron Berry. I left 7 messages on her voice recorder. No one will call me back.
All right, so let me ask you, Well, there is probable cause for the violation, but
But
do
that's
you
not-
wish to have contact then with him?
Yes,
Does he live with you?
yes, yes.
All right, I'm
Your
gonna
Honor, there is a no contact in the out on bond case, the 21 MM 8149,
Yeah.
which Mr. Cox signed in court in front of that first appearance judge that states that he could not be within 500 feet of this location.
But when? When is that from,
All right,
ma'am?
well, that's what the violation is, but I can change it to no hostile contact.
That would probably be great. I
All
mean, he's my husband. We're married, sir.
Okay, all right, well, but.
And I don't even understand how he was violated, and now he's looking at a felony. He doesn't have felony charges.
Okay, I'm making it no hostile contact, and is a recommendation on the bond?
Your Honor, given that he's out on bond for a bad DV against the same victim, state would ask-
Okay,
and he has prior violations of domestic injunctions, prior bad DVs, at
He
least
never has
two,
a violation, ma'am.
ma'am,
with the same exact victim, Your Honor.
When?
all right.
This seems to be an ongoing issue.
Can you
and
please
state is
tell me
still-
when, ma'am?
Ma'am, can I, please. State is still concerned at this time for the victim's safety,
I've never had
despite
one.
her testimony here today, given he's out on a bad DV. He does have a prior arrest for a violation of injunction and DV against the same victim, as well as
I gotta
prior
know
out-of-state history as well.
All right, there has been a bond posted, is that correct on this case?
Yes.
Okay, it's $2,000, so we'll just leave that bond in effect?
Are you taking any action on the out on bond case, Your Honor?
I'm sorry?
Are you taking any action on his out on bond case?
Oh,
I don't understand that.
the present case, I'm just gonna get, since we got the bond in the other case, I'm just gonna, give him personal cognizance bond on this,
Thank you, Your Honor.
all right?
So you're not taking
no
any,
action?
you're not taking any action on his out on bond case that he's out on a battery DV for?
I'm sorry?
You're not going to take any action on his out on bond case?
No,
Thank you, Your Honor.
all right.
What's the bond in this, the new charge?
On the new case is Rick, own cognizance?
ROR?
Or-
Okay.
Thank you, sir.
And state, did
It's
you
R-
amend the charge?
So
to-
he was ROR'd on a violation of a PTR, which could be held no bond.
That's what he just, and then you said you amended the charge to that 741.29 sub 6?
741296.
Okay, thank you.
Your Honor, just for the record, state objects to the
Thank you,
ROR.
Your Honor.
All right.
Good morning, Your Honor.
What's your name, sir?
My name is Jabdul Powell.
Okay, Mr. Powell, okay. You're charged with possession of cocaine and possession of cocaine with intent to sell or deliver. Let's see, is that on that's on a warrant, is that right? Yeah, by Judge Bain. And he had reduced the bond for $7,500 on the possession of cocaine with intent to deliver and $150 on possession of cocaine. Why are we back here today on this?
Your Honor, there was a reset due to the finding of PC on count 2, the possession of cocaine with intent to sell or deliver. I did obtain a new affidavit, and I have provided it to defense. May I approach?
Yes, you may.
Your Honor, in pertinent part, the new affidavit states on the first page that there was a canine alert to the vehicle, and the cocaine was found in Mr. Powell's crotch area that was approximately 3.5 grams. On the second page, in pertinent part, it states that the co-defendant, who was also within the vehicle, Ms. Schoolcraft, stated that she was introduced to Powell through a mutual friend when she was looking to buy drugs. Mr. Powell's known to sell drugs, not limited to fentanyl and heroin, and that she has purchased heroin from him several days prior behind an Einstein's Bagels on South Kirkman Road, and he's known to sell in high qualities. He also sells behind Outback Steakhouse. There is a representative from those businesses on South Kirkman Road stating that there is a suspect that normally drives a small pickup truck that sells drugs behind their locations. The vehicle that Mr. Powell was picked up in was a small pickup truck. The mother of the defendant has also said that her son is a drug dealer. When law enforcement spoke to the defendant, Mr. Powell, he advised that he was in that Walgreens shopping plaza to pick up his son from daycare. However, the defendant's mother stated that the child's daycare is approximately 3.5 miles from that plaza, therefore not giving a reasonable reason why he's in that location.
All right, any response from the state defense?
No argument from the defense at this time, Your Honor.
All right, I do find there to be probable cause for the charge of possession with intent to distribute. And we'll just leave the bonds as set by Judge Payne. What's that? Yeah, whatever conditions he ordered will renew. It's,
Madam Clerk, you had no drugs or alcohol in a random urinalysis?
Right. Random urinalysis, no contact, co-defendant, directly possess or consume any drugs or alcoholic beverages. Understand? Understand, sir?
No, sir.
All right, you are to submit to random urinalysis. So I guess you could be on pretrial release supervision to do that?
It's just RUAs through PTR, Your Honor.
Pardon?
It's just RUAs through PTR.
Okay, all right. And no contact directly or indirectly with the co-defendant, and do not possess or consume any alcoholic beverages or illegal drugs. Do you understand?
Yes, sir.
Okay.
Yes, sir.
All right.
Your Honor, what was the bond amount on the, again?
The bond was set, it's on count 1, possession of cocaine, $150. Count 2, possession of cocaine with intent to deliver, $7,500. Yes, we'll file the supplemental report. All right, thank you. What's your name, sir?
Christopher Corbett.
Okay, Mr. Corsett. Okay. Are these the new charges? Yes. Okay. You're charged, sir, with armed burglary of a dwelling with a firearm, battery, domestic violence, possession of firearm by a convicted felon, and possession of firearm with an altered serial number. Court does find there to be probable cause. Since there's probable cause for that, he's out on bond. Case 2021 CF 15650. He's out on bond. In that case, the court will revoke that bond.
It's 2021 CF 008033 AO that he's out on bond on, Your Honor.
That's what he's bonded out on?
That's what he's out on bond on.
Okay, that'll be revoked. And
Your Honor, in the instant case, count 1 is a first-degree felony that's punishable by life. Count 2 is an M1. Count 3 and F2.
What's for count 1?
I'm sorry?
What was the recommendation of count 1?
Since it's a first-degree felony that's punishable by life, state's asking that you hold him no bond pending an Arthur hearing.
Okay.
Set reasonable bonds as to 2, 3, and 4.
Okay. I'm having no bond on the armed burglary of a dwelling, the firearm, and $100 each on the other 3 charges. And you are to possess no firearms If you have any, they may need to be turned into the sheriff's office and, or ammunition also. All right, is there anything else?
Your Honor, state would also ask for a no contact with the victim or witnesses in this case.
Okay, no contact with the victim or witnesses in the case. All right, state your name, sir.
Mark Desir.
All right. All right, you're charged with contempt of court violation no contact order. I do find there to be probable cause. Point public defender. What bond recommendation?
Yes, Your Honor. Mr. Desir was here recently on a PBL Burgbat in 21 CF 15230. And one, he was picked up on that, the same victim. He had an out on bond case, BAT DV 21 MM 8127. Given that, and given that there is a no contact order in both of those cases, both against this same victim, and he's currently not entitled to bond on either of those cases, state's also asking for $20,000.
No bond. Okay. All right, it will be granted.
Your Honor, I believe state requested a $20,000 bond.
$20,000, Your Honor.
I'm
At
sorry,
this time,
20,000? Okay.
Your Honor could set no bond if you found no reasonable conditions that,
Okay, I'm at 20,000 reasonable. What, he's being held on another case?
he's revoked and has zero bond on the PBL otherwise.
Okay. All right.
The state would just ask that you further put in the order that there's still a no contact with this victim.
All right, and you, Mr. Desir, you have no contact with the victim, direct or indirect, no phone calls or anything? Yeah. State your name, please.
Kevin Harris, sir.
Okay, thank you. This is a warrant, I believe, out of,
Your Honor, I believe Mr. Harris is here on a warrant for the Aggravated with a pregnant person. And he also is here for an additional charge of BAT DV. Both charges stem from the same events.
all right, well, the warrant is out of Ninth Circuit for aggravated battery on a pregnant person. There was a $250 bond set on that case. Pardon? Oh, we have the victim here. Okay, would you swear her in?
Raise your right hand, please. You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right. Would you state your name, please?
Tabitha Monique Conway.
Okay, and what is your relationship with the defendant?
He's my husband.
Your husband, okay. And did you wish to have any contact with him?
Yes.
You do?
Hmm?
Does he live with you?
Yes, sir. Can I say something?
Yes.
At the moment, he's the only one working in the household due to the fact that I
I'm
lost
having
my.
trouble hearing you, I'm sorry. Can you speak a little bit louder? You can take your
At the
mask
moment,
down.
he's
to
the only
speak.
one working in the household due to the fact that I lost my job for refusing to get vaccinated. I mean, everything that's on the affidavit, like I told her that. I've been trying to call them for weeks at a time to tell them what really happened between us, that it was a misunderstanding, that he never raised his hand at me.
Um, all right, is there, okay. The new charge is battery, is that correct?
Yes, Your Honor. 21 MM 8700.
Okay. I do find there to be probable cause.
Your Honor, in regards to the BAT DV, state at this time is just asking for $500. As the warrant case, the aggravated on a pregnant person generally comes in at approximately $5,000. It's already treated as a subsidiary. So state's asking that you stay the aggravated on a pregnant person at $250 and set $5 on the BAT DV.
And he also does qualify for PTR.
It does qualify for pretrial release?
Yes, Your Honor.
Okay, okay, well, I'm gonna, leave the one at 250 and set the new one at 500 with pretrial release. You're to have no hostile contact with your wife, you understand that?
Yes, sir.
All right, do you own any firearms?
Yes, sir.
You're not to possess any firearms or ammunition, you understand?
Yes, sir.
All right,
And it's bond and PTR in both cases. Is that correct, Your Honor?
yes,
Excuse me, sir, may I say something?
500 on 250. Yeah. Okay, well, the other conditions will stand on the.
Speak.
Excuse me, sir.
Okay, well, I'm gonna change that to no hostile contact, and he may reside with her. You want him to reside with you?
Yes, sir. I wish not press charges. I've been trying to tell him that I've been trying to drop the charges for the longest. Like, I don't want to proceed with the case. Like,
Well, you have to talk to the state attorney. I can't do anything about that, okay? All right. Thank you. All right,
Alexander Mercado.
thank you. Yep. Let's see, your name, please?
Alexander Mercado.
Okay, Mr. Mercado, you're charged with domestic battery by strangulation. I find there to be probable cause. The victim is not present, is that right?
Yes, Your Honor.
All right. And, appoint the public defender is in all cases here. Is there a bond recommendation?
Your Honor, Mr. Mercado does qualify for pretrial release, so state has no objection to pretrial release with a $1,000 bond, given that this is an F3.
All right. All right, I'm going to, can you make $1,000 bond, sir?
I guess this is my first time going through this, so do I have to call, try to?
Yes or no, can you
Bondsman?
set a $1,000 bond?
Yeah, I guess I can try, yeah.
Okay, I'm gonna set a $1,000 bond and, no contact with the victim. And do you live with the victim at this point?
I did live with her before the incident, but I guess she's with her mom now.
Oh, okay, you need to have separate residence.
Yes.
Okay. And you own any firearms?
No, sir.
Okay, you're not to possess any firearms or ammunition. Okay,
Your Honor, is that $1,000 with pretrial release?
pardon?
Is that 1,000 with pretrial release?
Yes.
Your Honor, I also believe there was a child present.
Pardon?
So state would ask for the condition to comply with DCF if a DCF investigation were to go underway.
I think DCF showed up to my house already yesterday.
I can't hear you.
I think DCF showed up to the house and talked to my girlfriend yesterday about that.
State would just ask for the condition to comply with any DCF investigation.
Yes, you must comply with any conditions that they set, DCF. All right?
Sure.
All right, thank you. Okay, state your name, please.
Tequila Alcime.
Okay, and,
Your Honor,
yes,
may I have a moment to confer?
yes.
Your Honor, I also believe Ms. Alcime's co-defendant, Mr. Rutland, is also in custody. I don't know if you want to hear both of them at the same time to determine contact.
This is a co-combatant situation that the officer couldn't determine.
Your Honor, could we request Mr. Rutland come in as well?
Beg pardon?
Can we request Mr. Rutland, the other co-defendant, to come in as well so they can testify to contact?
Okay. All right, state your name, please.
Michael Rutland.
All right. Mr. Rutland, you are charged, along with Ms. Alcime, with battery domestic violence. I have found probable cause on both.
Your
What,
May I inquire as to contact?
yes, please.
Ms. Alcime, can you please state your relationship to Mr. Rutland? Okay. Are you afraid of him?
No, because we ain't only gonna have contact, just got to do.
Okay. And has anything like this ever happened before? Approximately how long ago would you say the last time was?
Quite not sure right now, but it has.
Okay. And do you want to have contact with Mr. Rutland while this case is pending?
Yes, due to the fact of the kids. Because we had a meeting on December the 8th for my daughter's school, she's in high school. We had to reschedule it, and we were stuck in here, so I couldn't reschedule.
Okay.
Yeah, contact just for the kids.
Okay. Mr. Rutland, can you please state your relationship to Ms. Alcime?
We got kids together. I ain't scared of her. I ain't afraid of her. It's just bad misunderstanding.
Okay. And would you like to have contact with her?
It don't matter. I ain't got nothing against her. We got kids together.
Do you mind giving me a yes or no, sir?
If we can have contact together, yes.
All right, thank you.
Are you two living together?
Off and on.
Well, when you get out, will you be living together?
You sure about that? Okay.
You say no, you will not, or you will be?
We won't.
Will not be.
Okay. Okay.
All right. Okay.
That what she want. That what she got.
Okay. Well, but you do want to have contact with him, or you do not want to have?
Yes, I just said
Okay.
I want to have contact due to the kids. We can't sit in the school meeting 500 feet. We have to have contact due to the sake of the kids. If it's nothing got to pertain them, no.
Okay, I'm going to set no hostile contact, And you must maintain separate residences. And,
That's up to him, because that's his resident.
Which mean I told you I ain't got no problem with that.
But he had
okay,
in the statement, he brought me out, so I thought I won't
okay, I think they're eligible for pretrial release.
They did, Your Honor, yes, both of them.
Okay, so we'll put them on pretrial release.
Your Honor, state would ask for,
Straight PTR.
Your Honor, given bad DVs, they cannot be put on straight PTR.
I guess you see, is that how we say it? Straight PTR, yeah.
Under Florida statutes, we cannot put them on straight non-monetary release.
Okay, well, I'm sorry, I'll make it PTR and ROR.
Your Honor,
Hostile contact means no physical arguments or fights or anything, you guys understand?
it wouldn't be an ROR and PTR, Your Honor, it's not really.
Okay, what is it?
State's
Okay.
asking for 100 and PTR on Miss Alchemy and 100 and PTR on Mr. Rutland.
I guess I'm making $100 on each of them.
Why we can't get out on RR? Like, I called the police in defense for myself, and I
Pardon?
got arrested. I said, why we can't get out on RR? I called the police in my defense, and I got arrested.
Well, because it looked like both of you were fighting each other, that's why. So,
I never-
well, I'm not here to determine whether that's true or not.
What are you ordering?
$100
All right.
plus PTR release on each one.
Okay.
It's 100 and PTR for both, right, Your Honor?
Yes. All right.
So it's just $100 bond out.
Pardon?
Just $100 bond out.
Yes. Plus pretrial release. All right. These are the out-of-county warrants. Would you state your name, please?
Nicole Borger.
All right, Ms. Borger, you're here on a warrant out of Citrus County. They have set no bond. I can't change that, but we'll have you be transported to Citrus County just as quickly as we can. Okay? Pardon? I don't know, do we need the PD at this point?
Yes, Your Honor,
Okay,
generally when there's
PD.
zero bond.
Okay, all right, PD's appointed, all right, thank you.
Your Honor, we're appointed just in case, that we don't want them to get lost in the system.
Okay, all right. All right, state your name, please.
Wilton Calthers.
Okay, Mr. Carthers? Okay, you're here on looks like 2 out-of-county warrants out of Lake County, aggravated stalking, domestic, attempted burglary. Let's see, the bond is set at $15,000 on the attempted burglary and no bond on the aggravated stalking. Public defenders appointed. This is out of Lake County. I can't change that bond. They'll just have to transport you there as quickly as possible. Okay.
All right, thank you.
All right, state your name, please.
Joseph Jake Lazardi.
Okay, Mr. Lozada, I'm appointed public defender to represent you. You are here on a warrants out of Lake County for sex offender failure to report, failure to update address, and failure to register. Bond is set at $5,000 on each count. So if you're able to post those, you may do so. Otherwise, you'll be transported to Lake County as soon as possible. Understand?
Yes, sir.
Good morning. State your name, please.
Rosemary Priest.
All right. Ms. Paris, is that right? Okay. You're here out of county warrant from Seminole County, driving while license suspended or revoked. But you are, I guess, they set a release on your own recognizance?
Uh-huh.
So you will be released then, okay? But you just need to report to Seminole County as quickly as possible to take.
Okay.
All right?
Okay.
All right.
Do we have a status for Scott
Are we going to do this one?
Allegat?
Do we have, all right, I'll go ahead and do this and then we'll do. All right, state your name, please. Okay, Ms. Smith, you're charged on a violation of probation out of Osceola County. They've set no bond, co-defendant is appointed, so you'll have to be transported there to take care of this, understand?
Yes, sir.
Okay, all right, we're going to do Mr. Scott. They picked him up? Oh, okay. Is the attorney on the line or something? Is he, Mr.? Oh, okay, well, I thought it was going to appear via link, but. Okay. All right, well, I don't know if he. Pardon? I'm sorry. Okay, sure.
Welcome to an Econo meeting. You are entering the meeting now.
All right, do we have anybody on the line? All right, I just told an attorney for Scott McCallum would be appearing. He has been already transported to Osceola County.
Okay, thank you, Your Honor.
Okay, what's your name?
Leah Hart, record.
I'm sorry, what's your name?
Last name Hartwell, Leah Hartwell for the record.
Okay, all right, thank you.
Thank you so much. Bye-bye.
Sure, bye. Okay, there we go. State your name, please.
Miguel Cotto.
Mr. Cotto, is that right?
Yes, sir.
Okay. You're here on a violation of probation warrant. Set a no bond by Judge Barber. So you will be, I would appoint public defender. And you'll be noticed when to appear in court. All right? All right, state your name, please.
Eric Hartley.
Eric Hartley, is that right? Okay. Let's see. You're here on a, looks like a violation of probation. violation of probation warrant. Public defender's appointed, I'm sorry, was there no bond on this? Okay, no bond, okay. So,
I did 7 months on this charge.
I'm sorry?
I did 7 months in the county jail for this charge. It should have been expunged already. I'm very well aware of the case you're looking at and the several other ones that are before you. And that should have been expunged already, sir. I just got out of county jail doing 7 months on this charge.
Well, you'll have to take that up with the, this is out of Orange County.
2019. Failure to register. I just got released in August. I was sentenced to probation and time served for 7 months county time from February 9th to August, I believe it's 28th.
Your Honor, it's still active.
Yes, I'm sorry. Yes.
It is still active, Your Honor. On 8/30/21, he admitted to the violation. He was found in violation. Probation was reinstated, and he got credit time served for the 203 he otherwise served, but had 6 months of community control with electronic monitoring, and that was of 8/30. Therefore, it's still active. Therefore, he needs to see the VOP judge.
So he's completed the probation?
He has not. He needs to see the VOP judge.
Okay, well, all right, you have to take it up with the court. And no bond. All right, state your name, please.
Ronald Lampone.
Okay, Mr. Lampone, let's see, you are. You're here on a violation of probation warrant. No bond, so you'll have to appear before the court to try to change that, okay? Understand?
Your Honor, may I speak on my behalf?
Yes.
I was violated on a technicality due to incomplete treatment that I was required through my probation. Is there any way the court can see that I can get a bond?
Yeah, well, the court who has the case will have to set the bond. I can't set it. All right? Sorry. All right, state your name, please.
Austin Wynn.
All right, Mr. Wynn, you're here on a violation of probation warrant signed by Judge Renee Roche. And a public defender be appointed. She set no bond. All right. State your name, please.
Aldrich Wright.
All right, Mr. Wright, you're here, violation of probation affidavit, looks like. For picking up a new arrest, set it, signed by Judge Wilson, and no bond set. All right.
I believe we have ROR motions next.
Okay. All right, state your name, please. Oh, Spanish we need to do. Okay.
Good morning, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn.
Okay, good, all right. And, okay, our first case is Jose Alexander Madrid Ramirez. State your name, please.
And Your Honor, if you allow me just a moment to connect to the headsets and confirm, please.
Yes.
Sí.
Your Honor, the interpreter can confirm the defendant is able to hear through the headsets. I will now proceed to ask him his name.
All right, thank you.
José Alexander Madrid Ramírez.
Jose Alexander Madrid Ramirez.
All right. Mr. Madrid Rodriguez, you're charged with no valid driver's license. I do find there to be probable cause. Bond recommendation?
Your Honor, state would just ask that you set the bond that is currently set at $500.
Defense would just request ROR.
I'm sorry?
Defense would request ROR. There's no criminal history, no failures to appear.
All right, are you able to post a $500 bond, Mr. Madrid Ramirez?
Sí, señor, sí puedo.
Yes, I can, sir.
Okay, then I will set it at $500. All right.
Your Honor, may the interpreter respectfully request the case number for this last defendant, please?
Yes, I'm sorry.
2021 CT 8072 AO.
Thank you, Madam Clerk. Thank you, Your Honor.
Okay. And state your name, please. I'm sorry. State your name, please.
Osvaldo Mesa Dominguez.
Osvaldo Mesa Dominguez.
All right, Mr. Dominguez, this is case number 2021 CF 15628 and, well, yeah, 15628. Okay, you're charged with aggravated assault with a weapon and a battery. You do find there any probable cause on recommendation by the state?
Your Honor, state would just ask that you set the bonds that are currently set at $5,100.
I'm sorry, how much for the first one?
State would ask that you stay the bonds at $5,100.
He does qualify for PTR.
If you're otherwise inclined to put him on PTR, state would ask for you to half the first one. So if you were inclined to put him on PTR, 2,500 on count 1 and 100 on count 2 with PTR.
Okay, I'm gonna, set a PTR with a bond of $100 on each count. And you're to have no contact, no, you're not to possess any weapon, firearms. If you have any, they must be turned over to the police, sheriff's department, or police department.
Do you want it surrendered in any sort of amount of time, Your Honor? 24 hours, 48 hours?
I'm sorry?
For the surrendering of the weapons or firearms, did you want it surrendered in any kind of time period, like 24 hours, 72 hours?
Yeah, 24 hours, yes, okay.
Your Honor, for the record, state would object. This is a third-degree felony. State would argue that $100 is incredibly low, given that the weapon involved was a knife, and given that the defendant does have a prior arrest history for battery.
So what are you asking?
And he has limited criminal ties. I believe his citizenship is to Mexico, so state's concerned about his willingness and ability to come back to court. The state originally asked if he's on pretrial release for $2,500 on count 1, $100 on count 2. All the reasons you just laid out.
All right, are you able to post $2,500 and $2,600? Okay, then I'll set it at that, all right. All right, anything else? All right, here's. State your name, please. Oh, I'm sorry, wait a minute here. State your name, please.
González Delgado.
All right, Mr. Gonzalez.
I'm sorry, Your Honor, my apologies. The interpreter requires clarification from the defendant.
Okay, I'm sorry. We just asked him to state his
José
name.
González Delgado.
Raúl González Delgado.
José.
Jose.
Okay, Mr. Gonzalez Delgado, you're on a warrant. Like 3 counts of first-degree murder resulting from distribution of fentanyl, and so there'd be 0 bond on those. And there's also a pending bond in case.
Your Honor, that out on bond was actually entered in error. It occurred after the date of this warrant. So he should not have been out on bond on that.
On the first one,
Yeah, that was closed entry error.
okay, so I will not, bond will remain the same on that case, okay.
Your Honor, as conditions, state would ask for no contact with the victim's family.
All right, no contact with victim's family. All right.
He is entitled to an Arthur hearing as well to set bond with his attorney downtown as he's being.
I'm sorry?
He's also entitled to an Arthur hearing as he's being held to bond on the charge with his attorney downtown,
Okay,
just for the record.
pardon?
Just for the record.
Okay, all right, thank you. Yeah, on the 3 counts, and then we'll just, no contact with the family and these. Any more Spanish cases?
Madam Clerk, may the interpreter respectfully request the case number for this last defendant, please?
Yeah.
2021 CF 15656AO.
Thank you, Madam Clerk. Your Honor, may the interpreter be excused at this time?
Yes,
Thank you, Your Honor. Have a good morning.
you too, thank you. Okay. Good morning, state your name, please.
Gerard Rudolph.
Okay, Mr. Rudolph, you are here on a capias for petty theft with 2 prior convictions. Let's see. Bond is set at $1,000. Let that remain. All right.
Your Honor, state would ask for no contact with victims or witnesses and a no return.
Okay, no contact with who's the store? I'm sorry, what's the store that?
It was at the Macy's.
Turn to the scene of the Florida Mall. Do we have a store?
Yes, Your Honor, it was the Macy's.
Macy's?
Yes, Your Honor.
Okay. All right, you understand that?
Actually, I don't, because when I went to court last week, they told me it was retail theft for the same case.
All right, well, okay, you're not, I'm not here to determine whether you're guilty or not, but whether there's probable cause. So you're not allowed to return to Macy's or to the Florida Mall, do you understand? Well, if he, yeah, no contact with the stores, but then, I mean, if he can't return there, he won't have contact. Is there a no contact order on there? I think a no return would be sufficient, is that correct?
Yes, Your Honor, and no contact with the witnesses at the store?
No contact with the victim employees?
Yes, Your Honor.
All right. All right, state your name, please.
What's that?
Your name?
Honor? Huh?
What's your name?
Oh, Van Michael Brown.
Okay, Mr. Brown, you're charged with assault on a law enforcement officer, trespass on property after warning and resisting an officer without violence. A public defender is appointed in all these cases, in this case. I find probable cause. Recommendation on the bond?
Your Honor, state would ask that you stay the bonds at $1,000 on one, and the other two are already treated as subsidiaries at $100, with a no contact and a no return to the old Cuban cafe.
Okay, that'll be,
Oh, hey, Your Honor.
yes.
My pharmacy is right next to the old Cuban cafe, and my bank is on the other side. All I was going was from the pharmacy to my bank to get some money. I never went into the old Cuban cafe.
Sorry, you don't have to talk about what happened. You don't have to talk about what happened. I'm just trying to get you out, okay?
Oh,
All right.
Your Honor, he's on social security disability. I don't believe it's been for an extended period of time. I would just have you set a very low monetary bond, or if you're inclined, release on own recognizance.
Your Honor, respectfully, state would object to both a lower monetary bond as well as ROR. He has at least 2 prior failures to appear, one as recently as last year. He has at least 3 prior VOPs showing an inability to comply with court orders, as well as a pretty extensive history with other violent offenses, as well as other trespass offenses.
All right.
And state doesn't believe an ROR is reasonable on a crime of violence, Your Honor, which assault on a Leo is.
All right, I think some bonds, can you post $500 total bond?
yeah, but I'd like to be out of here today. Can
You cannot?
I get out of here today, Your Honor? Can y'all have to get a bondsman, I guess.
Well, I'll make the bond at $200 on the first count and $100 on each of the second counts, so total of $400.
Okay, Your Honor, can I ask you, when I go back, I told my pharmacy is on the one side of the old Cuban cafe, and my bank is on, I have to go back and forth. Can I go, I never went in the Cuban cafe. I went past, I had to go in the parking lot, but I never went into the place.
Well, I don't.
You know what I'm saying? And I had to get money for, I had to take medicine.
Okay, well, I didn't put any,
I don't have no trouble with the old Cuban cafe.
all right.
I gave them a $25 tip one time at the old Cuban cafe. So I don't know why they're doing this.
Your Honor, there is an active trespass warning.
I'm sorry?
In effect. There is an active trespass warning in effect. Therefore, he cannot be on or around Old Cuban Cafe property. I believe that's something he can talk to his lawyer about, how to go to his pharmacy and or his bank.
All right, so you must obey the trespass warning. If your banks, and usually they have other branches, but you just can't get on, it's the property of the old Cuban Cafe, I believe, is that right?
Yes, Your Honor.
Okay, so you just can't, you cannot go there on, no return to the old Cuban Cafe. Comply with trespass order.
Okay, well, can I get out or what? Okay.
Is that? Oh, okay. Okay, all right, so we have a, that's, what, is this one? Okay, Arab interpreter, okay, all right. All right, I'd ask the Arab interpreter to state your name.
Bushra Ilwali.
Okay, have you been sworn in today?
Yes, Your Honor.
Okay, all right. All right, do you just need headphones on? Oh, don't use headphones. Okay, state your name, please.
Khalid Muhammad Ahmed Bajnet.
All right. Pardon? What about it? Okay. Yeah. Oh, she said she already. Okay, sir, your, this is case number 2021 MM 8706A0. You're charged with battery, $500.
السلام عليكم.
السلام ورحمة الله.
أهلا بك. أنا اسمي بشرى مترجمة عربي. بترجم لكم. الملف تبعك هو 2021 8706 A0. عليك حكم بالتعدي.
والله ما أدري كيف حبرر لك بس عاد يعني ما لا أنا في محل عام يعني حتى أنا قلت لها شكرا حطيت يدي في كتفها بس وطلعت برا عادي وصلت عند الباب حق المول جاني الشرطة يقول لي أنت تتحرش فيها كيف أتحرش فيها محل عام مش تفكير زي كذا أنا بس أنا ما أدري إيش
I really don't know what's going on. I haven't done anything. All I've done is said thank you, and it just touched the shoulder. And when I left the mall, the police officer told me you were harassing her. I just don't understand.
All right, well, I'm not here to determine whether you're guilty or not guilty. I'm just to determine probable cause and set the bond.
طبعا أنا هنا ما عشان أقول لك إنك مذنب أو غير مذنب، أنا بس بقول لك شنو السبب اللي صاير وشنو هي المستند أو السند أو المبلغ اللي هو 500. طبعا ما قلت شوي.
هذا 500 يعني غرامة ولا باوند ولا؟
So what is the 500? Is it a bond? Was it a fine or?
Well, okay. You're charged with battery, and if court finds probable cause, the recommendation on the bond.
Your Honor, state would ask that you stay the bond at 500.
Are you able to post $500 bond, sir?
الكفالة بمبلغ 500 والحطوا عليك إنه ضرب يعني أو اعتداء بيسموه. طب قادر تدفع 500 تبعت الكفالة؟
أنا عندي عندهم كاش عندهم 600 وشوية ما عندي مشكلة.
No problem. They had in their possession my money, which is like 600 and some change. No problem.
All right. $500 bond, you're to have no contact with the victim.
$500 لكفالة وما يكون عندك أي تواصل مع الضحية.
يعني ما أرجع مرة ثانية كورت ولا شيء؟
So does it mean I don't have to come back to court or anything, right?
Yes, you do.
لا حترجع.
طيب أنا مش عارف أنا هومليس وما عندي عنوان كيف أعرف متى الكورت حقي؟
I'm actually homeless and I don't have an address. How would I know when is my court date?
Well, you'll need to talk with the public defender's office. You'll get notice to appear. And let's see.
Tomorrow, today?
Okay, thank you, sir.
Your Honor, state would also request a no return to the Florida Mall located at 8001 South OBT.
All right, yeah, you're not to return to Florida Mall, 8001 South Orange Blossom Trail.
Your Honor.
Your Honor, could you please repeat the address one more time? 8000 South?
Yeah, it's 8001 South Orange Blossom Trail.
ثانك يو. وبالنسبه للموضوع تبع العنوان فلازم تتكلم مع المحامي الدفاع بخصوصه. بالنسبه للمول هذا ما عندك الحق انك تيجي تروح عليهم مره ثانيه اللي هو بالعنوان 8001 ساوث نورث بوسطن.
اوكي.
ما تقدر تروح لهذا المول.
معلوم.
Understandable.
Okay.
Does he, Your Honor, does he also have a failure to appear?
He has another case, Your Honor.
Okay, there's a warrant for failure to appear.
That's correct, Your Honor.
Okay, yeah, and that's set at $2,000. So leave that set. Okay.
Can the interpreter tell our client that he has a failure to appear and the bond is set at 2,000?
Yes, sir. صار عندك فشل في الظهور أو ما جيت ما في الحضور فتشرج عليك كفالة $2000.
قال لي 500 الحين.
But he told me 500.
It's another case.
والله ما عندي أنا هوملس والله كنت أشتغل دحين ما عندي يعني كل اللي عندي هذه يعني دحين ما أطلع إلا بال2000.
ده ملف تاني.
هذا أدفع غرامة بعدين يعني.
I really don't have the money and I'm actually homeless and I don't have a job. Do I have to pay it later or was it a...
Once you have to post, you can get with the bondsman to post it. All right, okay.
Your Honor, on the failure to appear, state would request also a no return. That's the links at 455 North Garland.
You can be excused. Thank you.
We'll waive his appearance, Your Honor, if appointed.
Okay, all right. Next case come,
Are you
Are we
waiving
not-
his appearance, Your Honor?
We're not addressing Mr. Joyner?
pardon?
Are you resetting Mr. Joyner, or are you waiving his appearance?
Am I doing what? I'm sorry.
With Mr. Joyner, are you resetting him, or are you waiving his appearance?
Oh, no, oh, he's here, right?
No, he refused, Your Honor. Mr.
Oh, he
Joyner
refused?
refused.
All right, well, I'm just going to go ahead and I'll find probable cause and bond will be $500.
How much, Your Honor? How much bond?
500?
Can we disconnect the, I don't think we need the language line.
I'm sorry?
I think the language line is still connected.
Yes, I'm still here.
Oh, you can be
Yes, sir.
excused. I'm sorry. Thank you.
Yes, Your Honor, no problem. Thank you for using our service. You have a good day.
All right, take care. Okay. Yeah, PD is appointed in all these cases, yep. Excuse me. Okay, state your name, sir.
Evan Williams.
All right, Mr. Williams, you're charged with possession of drug paraphernalia. Find there to be probable cause.
Your Honor, state's going to announce a no information.
No information, you're going to announce? Okay, so his case is dropped? All right, so you'll be released, the case is dropped. All right. All right, state your name, please.
Lebanon Bikash.
All right, Mr. Bakash, you're here on a capias from Orange County for failure to appear on trespass other than structure. Bond is set at $250. Can you
Your Honor,
post?
Your Honor, there was an offer to resolve from the state of an adjudication of guilt, credit time served, and no return to any UCF properties. I had a chance to speak with Mr. Bakaj, and I believe he wishes to resolve today with a no contest plea.
That is correct, Your Honor.
All right, do we have plea forms for them to review?
They do.
Yes, I spoke with him in the back before court, and I handed him a plea form to review, as well as went over the rights to be waived, as well as any issues with citizenship or probation. I believe he still wishes to enter a plea.
Okay, all right. Do you understand all that, Mr. Bakaj?
I do.
All right, and do you understand the rights that you're giving up by entering this plea?
Your Honor, may you swear him in first?
Pardon, oh yeah, put him
Swear him in, please. Thank you.
Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. Bakaj, did you read all the rights listed on the plea form?
I did.
You understand them all?
I do.
And do you have any questions about it?
I don't.
Are you under the influence of any drugs, medication, or alcohol?
No.
Do you have any mental conditions which would interfere with your ability to understand what we're doing here today?
No.
And did you have sufficient time to discuss the case with your attorney?
I did.
You totally satisfied with his advice and recommendations?
Definitely.
All right, and you understand what the plea offer is?
I do.
And would you restate that, counsel? I mean, is this acceptable to the state?
Yes, Your Honor. The offer was an adjudication of guilt, credit time served, no return to any UCF properties, and there's also a cost of investigation of $76 to UCF PD.
And what about court costs?
Court costs, Your Honor.
Okay, and how much are court costs? $273 altogether?
$76, any cents?
Is that right? Like 273? Is that the right?
273 plus the
All right,
cost
yeah.
of investigation.
Pardon?
$273 and plus the cost of investigation of $76.
Well, do we have a cost of investigation?
Yes, Your Honor. $76
That's the $76.
UCF
Okay.
PD.
All right, do you understand all that?
I do.
All right, and the, all right, would the state state a factual basis for the case?
Yes, Your Honor. On or about August 27th, 2021, law enforcement responded to the Domino's Pizza UCF campus for a suspicious person. The defendant is located and law enforcement checked, and the defendant was previously trespassed 7/23/21, 2/20/20, 2/23/20, also in 2017 and 2015 from the property. The defendant informed he tried to contact someone earlier but was unsuccessful and remained on campus. Defendant was arrested and a new trespass warning was issued. All events occurred in Orange County, Florida.
All right, you understand the facts the state's prepared to present if this case were to go to trial?
I do.
All right, counsel, do you agree that's a sufficient factual basis to support the plea?
For the purposes of the plea, yes, Your Honor.
Okay, court, then we'll accept your plea, finds made knowingly, voluntarily, intelligently. You've had a competent advice of competent counsel with whom you're totally satisfied, and there's a sufficient factual basis to support it. And you're ready to proceed to sentencing?
I'm sorry, Your Honor?
Yeah, are you ready to proceed to sentencing at this point?
Yes.
All right, then the court will adjudicate you guilty, be sentence of time, how much time served do we have? 4 days, credit for 4 days time served. There'll be $76 cost of investigation and court costs of $273. Are you able to make payments on those costs?
No.
Well, I mean, are you employed?
Well, not now. Since I got arrested, I don't think so.
All right, well, I'm just gonna say you must pay these costs within 1 year of today. Understand?
All right.
Your Honor, I believe there was a no return as well.
Yeah, no, okay, no return to the,
Any UCF property, Your Honor.
where is it?
It's all of UCF properties.
Okay, all right, you understand that? Okay, all right.
Just a moment to confer, Your Honor. All right, take care. Your Honor, may I approach?
Yes. Oh, I need him back out just a second. All right, do you understand, that, okay, if you wish to appeal the plea and sentence today, you must do so in writing within 30 days, you lose the right to appeal. If you do decide to appeal and need a lawyer appointed to handle the appeal, one to be appointed for you. Do you understand?
I do.
Okay, all right, thank you. Excuse me. Well, PD, yeah, PD is appointed.
Okay, do you want to charge the dirt fee and the PD lien?
Pardon?
Do you want to charge the $50 dirt fee and the $50 lien?
I'll waive that now since I didn't tell him. All right?
Can I ask about it?
Pardon? Oh, yeah, I'm sorry. Okay. Okay, state your name, please.
Cyrus Brown.
So, Mr. Brown?
Yes, Your Honor.
Okay. You're charged with disorderly conduct. Court finds there to be probable cause.
Your Honor, given that this is a city ordinance case,
Beg pardon?
given that this is a city ordinance case, the state has been authorized on the city's behalf to offer a withhold of adjudication and credit time served.
All right, so you'd be with credit for time served, withhold adjudication?
Yes, Your Honor.
Okay, and the court costs?
Yes, Your Honor.
How much? 270, is it more for?
Are you appointing the PD?
Yeah.
Okay, so with the PD, fees, it'll be $323. So court costs
So the total cost of PD is 323?
Your Honor, I wouldn't have you appoint us. I spoke with Mr. Brown as a friend of the court, so that avoids any PD fees.
Okay, so we won't do the PD thing, so the total will be how much? $223. All right, do you have the plea form?
Yes, Your Honor, I did speak with Mr. Brown about the state's offer as well as handed him a plea form to review. He has reviewed it, and I believe he wishes to resolve with a no contest plea.
All right, so do you, did you read the plea form, sir?
Yes, sir.
Do you understand all the rights listed on the form?
Yes, sir.
Oh, place under oath, I'm sorry.
You swear to tell the truth, the whole truth, and nothing but the truth?
All right, so, sir, did you read the plea form?
Yes.
And do you understand all the rights listed on the form?
Yes, sir.
All right, any questions about any of them?
No, sir.
Are you under the influence of any drugs, medication, or alcohol?
No.
Did you have a sufficient time to discuss the case with the attorney?
Yes.
And are you totally satisfied with his advice and representation?
Yes.
Do you have any mental conditions which might interfere with your ability to understand what we're doing here today?
No.
And do you read, write, and understand the English language?
Yes.
All right. Okay. And do you understand the terms of the agreement?
Yes.
Okay. And, all right. And how do you wish to plead to the charge?
No contest.
All right. Anybody forced you or pressured you to enter this plea?
No.
Doing so of your own free will?
Yes.
You feel it's in your best interest to accept the plea agreement?
Yes.
All right, the court will accept your plea, find it's made knowingly, voluntarily, intelligently, competent to enter the plea, had advice of competent counsel, whom you're totally satisfied, and there's a sufficient factual basis to support it. And we'll proceed to sentencing. Anything else you want to say? Okay. Court will accept the negotiated plea and withhold adjudication of guilt. How many days time, sir?
2 days, Your Honor.
2 days, 2 days time served. And court costs of how much?
$223.
223?
Yes, sir.
All right. Are you employed, sir?
No.
Okay. All right, I think I'll just reduce that to a judgment. Okay?
It's fine, Your Honor.
All right. And if for any reason you wish to appeal the plea and sentence today, you must do so in writing within 30 days. You lose the right to appeal. Do you decide to appeal, need a lawyer appointed to handle the appeal, one will be appointed for you. Do you understand, Mr. Brown? All right, good luck. Thank you. All right, state your name, please.
Junior Clark.
Okay, Mr. Clark, is that right? Mr. Clark, is that your name?
Yes, sir.
Okay, and you're charged with possession of open container of alcoholic beverages, where it finds probable cause. Is there a plea offer in this case?
Yes, Your Honor. Also, given that it is a city ordinance case, I've been authorized on the city's behalf to offer a withhold and credit time served as well.
Okay.
And Your Honor, I did speak with Mr. Clark as a friend of the court, went over the rights to be waived and the issues with entering a plea, citizenship and probationary issues. And I believe Mr. Clark still wishes to enter a plea of no contest today.
All right, is he on probation for something else?
No,
Okay,
no, I was just informing him of any issues that would arise if that were the case.
all right.
Raise your right hand, please. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right. State your name again, please.
Roger Junior Clark.
Okay, do you read, write, and understand the English language?
Yes, sir.
Did you read the plea form all the way through and sign it?
Yes, sir.
Did you understand all your rights listed on the form as well as the terms and conditions of the agreement?
Yes, sir.
All right, are you under the influence of any drugs, medication, or alcohol?
Not now, Your Honor.
Did you have any do you have any mental conditions which might interfere with your ability to understand what you're doing here today?
No, sir.
All right, and did you have sufficient time to talk to the attorney about the plea?
Yes, sir.
Are you totally satisfied with his advice and representation?
Yes, sir.
All right, and has anybody forced you or pressured you to enter this plea?
No, sir.
Doing so of your own free will?
Yes, sir.
You feel it's in your own best interest to enter the plea?
Yes, sir.
All right, and how do you plead?
Plead no contest, Your Honor.
Contest. All right, and what's the factual basis?
On or about 12/10 at 2021, law enforcement was on active patrol when he observed the defendant with an open bottle of beer, a Bud Light at 4.2 alcohol volume on city property. All events occurred in Orange County, Florida.
All right. Court will accept your plea, findings made knowingly, voluntarily, intelligently, you're competent of the plea, you've had advice of competent counsel, with whom you're totally satisfied. There's a sufficient factual basis to support it. Any reason we can't proceed to sentencing at this point?
That's
Any
fine,
reason
Your
we
Honor.
can't proceed to sentencing? You ready to be sentenced?
Yes, sir.
All right. Then in accordance with the plea agreement, the court will withhold adjudication of guilt, sentence you to how many days?
2 days, Your Honor.
2 days and 2 days' time served. And the court costs are how much?
$223.
$223. Okay. Are you employed, sir? Are you employed?
No, sir.
All right. I'm going to reduce the court cost to a judgment. All right.
Yes, sir.
All right, if for any reason you wish to appeal the plea and sentence today, you must do so in writing within 30 days. You lose the right to appeal. If you decide to appeal, need a lawyer appointed to handle the appeal, one would be appointed for you. Do you understand?
Yes, sir.
All right, good luck. All right, state your name, please.
Freddie Lamb.
All right, and, okay, Mr. Lame, is that right?
Yes.
Okay, and you're charged with possession of open container of alcohol, find probable cause. Is there a plea agreement in this case?
Yes, Your Honor. I've again been authorized on the city's behalf to offer a withhold and credit time served.
And as a friend of the court, Your Honor, I did have a chance to speak with Mr. Lamb about that offer, as well as handed him a plea form to review. We reviewed it. And I believe he wishes to resolve with a no contest plea today.
All right. And why don't you go ahead and give me the factual basis at this point?
Yes, Your Honor, on or about December 9th at 2021, law enforcement was on active patrol when they observed the defendant on city property with an open beer can of Colt 45 with the alcohol volume of 8.5%. All events occurred in Orange County, Florida.
I do.
All right, state your name again, please.
Freddie Lamb.
All right, sir, do you read, write, and understand the English language?
Yes, sir.
Did you read the plea form all the way through and sign it?
Yes.
Okay, you signed it now, or you're signing it now? All right, you have now signed it, is that correct?
Sir?
You have now signed that form, correct?
Right.
You understand all the rights listed on the form as well as the terms and conditions of the agreement?
Yes, sir.
And did, are you under any, or influence any drugs, or medication, or alcohol?
No, sir.
Do you have any mental conditions which might interfere with your ability to understand what we're doing here today?
No, sir.
And did you have sufficient time to discuss the case with your attorney, including the evidence stated as against you, any possible motions or defenses you may have, the rights, terms, and conditions in the agreement, and whether it's in your best interest to accept this plea?
Can you repeat the question, Your Honor?
All right. Did you have enough time to discuss the case with your attorney, including the evidence the state has against you, any possible defenses you may have to the charges of the rights, terms, and conditions of the agreement, and whether it's in your best interest to accept the plea?
Yes, sir.
All right. You're totally satisfied with his advice and representation?
Sir?
Are you totally satisfied with his advice and representation?
Yes, sir.
All right. I might have already asked you, but did you understand all the rights on the form?
Yes, sir.
Okay. All right. And how do you plead?
No contest.
All right. Court will accept your plea, find it's made knowingly, voluntarily, intelligently, you're competent in the plea, you've had advice of competent counsel, then you're totally satisfied. There is a sufficient factual basis to support it. Ready to proceed to sentencing?
Yes, sir.
All right. Okay, anything you want to say before I propose the sentence?
No, sir.
All right. Court will withhold adjudication of guilt. How much time served is there?
2 days, Your Honor.
2 days, 2 days' time served. And the court costs of $223?
Yes.
All right. Are you working, sir? I'm going to reduce that to a judgment. All right. If for any reason you wish to appeal the plea and sentence today, you must do so in writing within 30 days. You lose the right to appeal. If you do decide to appeal and need a lawyer appointed to handle the appeal, one would be appointed for you. Do you understand?
Yes, sir.
All right. Okay, good luck. Okay, next case. What's your name, please? State your name.
Stephen McCarter.
Okay, Mr. McCarter, you're charged with disorderly conduct. Court finds probable cause. Is there a plea agreement in this case?
Yes, Your Honor. Given that it is a city case, I've been authorized on the city's behalf to offer a withhold credit time served.
Your Honor, I did have a chance to speak with Mr. McCarter in the back and hand him a plea form to review. We reviewed that. The state's offer, as well as any issues as a result of entering a plea. I believe he wishes to enter a plea at no contest, Your Honor.
Raise your right hand, please. Swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. First of all, I'm going to ask for a factual basis.
On or about December 9th, 2021, law enforcement was on active patrol on city property when he observed the defendant standing on the median approaching stopped cars at the intersection. Law enforcement observed the defendant approach the passenger side of a car accepting cash, reaching across the vehicle to give it to him. All events occurred in Orange County, Florida.
All right. Now, Mr. McCarter, do you read, write, and understand the English language?
Yes, sir.
Did you read the plea form all the way through and sign it?
Yes, sir.
Did you understand all the rights listed on the form as well as the terms and conditions of the agreement?
Yes, sir.
All right. Are you under influence of any drugs, medication, or alcohol?
No, sir.
Do you have any mental conditions which might interfere with your ability to understand what we're doing here today?
No, sir.
Did you have enough time to discuss the case with your attorney, including the evidence the state has against you, any possible motions or defenses you may have, rights, terms, and conditions of the agreement, and whether it's in your best interest to accept this plea?
Yes, sir.
Are you totally satisfied with his advice and representation?
Yes, sir.
All right. How do you plead to the charge of disorderly conduct?
No contest.
Has anybody forced you or pressured you to enter the plea?
No, sir.
And do you feel it's in your best interest to accept this plea agreement?
Yes, sir.
All right. And I note he has signed the plea form. Court will accept your plea findings, make knowingly, voluntarily, intelligently. You're competent in the plea. You've had advice of competent counsel. I think you're totally satisfied. There's a sufficient factual basis to support it. You ready to proceed to sentencing, sir?
Yes, sir.
All right. Anything you want to say before I impose sentence?
No, sir.
All right. Then the court will accept the negotiated plea, withhold adjudication of guilt, sentence you to 2 days of 2 days' time served. Court costs $223.
Yes.
And are you working, sir?
No, sir.
Yes, you are?
No, sir.
No? Okay, I'm going to reduce the fees to a judgment. All right. If for any reason you wish to appeal the plea and sentence, you must do so in writing within 30 days. You lose the right to appeal. If you decide to appeal, need a lawyer appointed to handle the appeal. One would be appointed for you. Do you understand?
Yes, sir.
All right, good luck. Thank you.
Your Honor may approach.
Yes. Thank you.
Your Honor, Raymond Damus, bonded.
I'm sorry?
Raymond Damus, bonded.
Oh, okay. Oh, okay, good. Okay, state your name, please.
Dennis Depew.
Okay, Mr. Pugh, you're charged with driving while license suspended or revoked. Find probable cause for that. And $500 bond on that charge?
Yes, Your Honor.
Okay, set bond to $500. And now you got a problem because you had a previous case of a driving while license suspended or revoked. Pardon?
She just answered the phone.
Yeah, it was 500. This one,
Your Honor, would you consider revoking and doubling the out-on-bond cases?
do what?
Revoke, if you are inclined to revoke the out-on-bond cases, would you consider revoking and doubling?
What, revoke them?
I would have you take no action, but if, I heard you considering what to do with the out-on-bond cases.
What's the state's position?
Your Honor, this out-on-bond cases allegedly occurred approximately a month ago, on November 2nd.
Right.
And they are arguably the same exact offenses that he's charged with today, potentially with an addition of a fleeing and attempting to elude. So state would ask that you revoke and double and not revoke outright, given that they're just traffic.
Yeah,
I believe his bond on the Dwillis, the 7276, was 500. So state would ask that you revoke and set it at 1,000.
Yeah, I'm afraid since it's so recent, he just didn't, he kept driving, so I'm gonna revoke the bond in 2021 25520.
No, those aren't the case numbers, Your Honor.
Okay, I'm sorry. It's, I was just reading what was on.
He's here on 2021 CT 7276
7276.
and 21 CT 7278.
Okay, yeah, okay. Revoking those, yes.
Are you doing no bond?
Yeah, no bond on those.
But, Your Honor, would you just consider one more time just revoking and doubling? It would be, I don't know what the bond amount was in 7278,
500.
and then 500 on 7276 as well?
Yep.
Yeah.
So it'd be another $2,000 bond, and I believe Mr. Pugh would tell the court that he would not drive while out on bond and without a valid license.
Yes, sir.
Your Honor, the state's only concern with that is arguably the beginning of the instant case that he's before today. He apparently fled from law enforcement on 12/2, so that's state's only concern. However, we'll leave it within your discretion. I believe he also has an open Lake County Dwillis as well.
Well, I'm gonna revoke the bond. You didn't, this so soon after your other cases, you're still driving, so I'm gonna revoke the bond.
Send an email today. That's what you want.
All right. Pardon? Case number? Say the case number? Okay. All right, state your name, please. Mr. Alexander? Okay, this is case number 2021 CF 15627. You're charged with criminal mischief. I do find probable cause. Recommendation on the bond?
Your Honor, state would ask that you stay the bond at 1,000 as currently set with a no contact and a no return.
Okay, all right. The court will keep the bond at $1,000. No contact with the victim, no return to the residence of the victim.
Yes, Your Honor, it was the 7-Eleven at 605 West Colonial.
7-Eleven parking lot, okay, on Edgewater Drive, okay. All right. Anything else?
Nothing from the state, Your Honor.
All right, state your name, please.
Morning, sir. Odette Alvarado.
All right, Ms. Alvarado, you're charged with possession of cocaine. Court finds probable cause, or was there a warrant? Let's see. Was that- Yeah, there's probable cause, I guess, yeah, okay. Court finds probable cause. State recommend,
Your Honor, state's asking that you stay the bond with a condition of no contact with any known drug dealers and no drugs or alcohol without a valid prescription. I believe she's also out on bond for a similar charge as well.
okay, so $1,000 on the new case?
Yes, Your Honor.
Okay. And what's your position on the pending case?
Your Honor, the pending case, the arrest on that was 10/27, so approximately a month and a half ago. It came in possession of cocaine, possession of a controlled substance, and drug paraphernalia. I don't believe state has filed on it yet, as we're waiting on FDLE. So I'll leave it within your discretion.
Yeah, I'm going to revoke the bond in that pending case. Due to the fact that you were already out on bond, you got the same type of charge. Pardon? Well, since I revoked the bond on the one, no, the conditions. No. All right, we have an attorney in the next case, I believe. I need to push it. No. Okay.
Welcome to an Acano meeting. You are entering the meeting now.
All right, do I have
You are
Attorney,
the only
Hyde?
participant.
Do I have Attorney Hyde on the line?
No one's there.
Okay.
47669.
Pardon? You what? Haven't heard from, okay. All right, state your name, please.
Brendan Orenga.
Okay, okay, you're here on a warrant or capias, Orange County, for aggravated assault with a deadly weapon. Well, actually, it's for failure to appear for that charge. It's aggravated assault and deadly weapon, violation of domestic violence injunction, domestic violence battery. So bond is set at 0. And so if you want to try to change that, you need to go to the judge that has the case. All right? Okay. I guess I should just hang that up then. Might as well, 'cause we're not there. Yeah, okay, there you go. No, right. Deadline's not-
This Burton? Looks like his bond's pending. Yeah, Anilus, last name? His last name's Anilus? Yeah, it looks like his bond's pending. This next guy, his bond's pending.
Who, Burton?
Burton and Anilus, yeah.
Yes. Yeah. Bonded already? Okay.
No, he's here. He's in front of me.
Oh, he's here? Didn't need an interpreter or anything?
No.
In that event, state would just ask that you stay as bond, Your Honor.
All right, state your name, please.
Burton English.
All right. You're charged with carrying a concealed firearm. Find, let's see. There is a probable cause for that. What's the recommendation for the bond?
Your Honor, state would ask that you stay the 2,500, particularly given that it's already pending at this point. With
Yeah, his bond's been paid, Your Honor.
Pardon?
His bond's been paid.
State would just ask for the condition of no weapons, firearms, or ammunition, and no contact with the co-defendant.
It's $2,500 bond, is it? Okay. Yes, sir.
Could you repeat? He's bonded, Your Honor?
Pardon?
He's bonded, Your Honor? Is that confirmed?
He's bonded?
Pre-trial.
I mean, yeah, he's bonded out.
Oh, but he
I don't-
has, okay, so he's
yeah,
bonded out,
he's-
okay.
His bond's pending. They're
He just hasn't
processing it now.
been released yet?
Yeah, they're processing it now, Your Honor.
Okay, all right, so,
So no condition?
well, I put in the,
Disappointed?
well, he's already posted the bond, but
Your Honor, can we also be appointed in this case?
yes, okay. Yeah, well, since I already posted bond, I don't think I can have additional conditions.
You appointed the
Send your
people.
opinion.
Appointed.
You,
Pardon?
so you just want to stay the 500 and appoint the people?
Yeah, 2,500, yeah.
No condition?
No condition.
Okay.
Okay, all right, so you're excused.
Thank you.
All right, state your name, please.
Elijah Barnes.
All right, Mr. Barnes, you have charges of possession of firearm, commission of a felony, carrying a concealed firearm, possession of cocaine, possession of oxycodone, and resisting an officer without violence. The court finds probable cause. The bonds were set at $5,000 on count 1, $150 on 2, 3, and 4, and $100 on count 5. Are you able to post those bonds?
Yes, Your Honor.
Okay, all right, court will leave the bond set there. And you're to not possess any firearms or ammunition, and not to possess or use any illegal drugs or controlled substances. Do you understand?
No, sir, can you repeat that, please?
All right.
Could you repeat that, Your Honor?
Pardon?
Could you repeat those conditions again, Your Honor?
The conditions were, well, it was $5,000 on count 1, and it was $150. Okay, $150 on counts 2, 3, and 4, $100 on count 5. Yeah, no, you may not have possession of any firearms. If you have any, they must be turned over to law enforcement. No, not to possess or use any controlled substances or alcohol. Understand?
Your Honor, state would also ask for no contact with the co-defendant.
I'm sorry?
State would also request no contact with the co-defendant, DeAndre Holmes.
All right, no contact. All right, with the co-defendant. All right. State your name, please.
Jimsley Sherzard.
All right, you are charged with Capias, violation of probation. On the original charge, possession of firearm by a person found to committed a delinquent act, and the bond is set at 0. And so if you want that change, you got to go before the court as the case. All right?
Damian Clark.
Okay, Mr. Clark, you are here on looks like a warrant for sexual battery on a physically helpless person. Bond is set at 0 by Judge Roach, so that, I will not change that. All right?
Your Honor, I believe this is just an F1. It's not a PBL or capital offense. Therefore, I believe Mr. Clark is entitled to a bond.
To a bond, okay.
State's asking for $250,000, Your Honor, largely taking into account he does have previous criminal history of kidnapping, attempted sex bat, and false imprisonment.
I'm, I know the charge, I'm going to set a $10,000 bond then.
Your Honor, it's a first-degree felony.
Pardon?
It's a first-degree felony, Your Honor. State would argue that's
much
incredibly
should it be?
unreasonable. I'm sorry?
How much should it be?
The state asked for
I'm
$250,000.
sorry, 250,000, okay, yes, okay. $250,000. All right. No contact with the victim.
And state would also ask for no return to the apartment.
No return to the apartment. All right, state your name, please.
Tracy Andre Clark Jr., Your Honor.
Clark, you are here on a capias for 4 counts of failure to appear on original charges of unlawful use of false fictitious name in an application for a driver's license. Bond was set at 0. Court will leave that at 0. All right. All right, state your name, please.
Nathan Oliver Dixon.
All right, Mr. Dixon, you're charged, let's see, with introduction of contraband into a detention facility, possession of methamphetamine, possession of fentanyl. There is probable cause. Bond set at $1,000 on count 1.
Yes, Your Honor, state would ask that you
50
stay
on
them.
the other 2 counts each.
Yes.
So court will keep those bonds. Public defenders appointed. All. I'm sorry?
Jacarius Grace is medical.
Yeah. Yes.
You're going to waive Mr. Grace? Medical.
Okay, so you have to reset it. Yeah, I guess we'll reset it.
Your Honor, I believe the PD may waive.
I'm sorry?
We'll waive the appearance for Mr. Grace,
Waive the
Your Honor.
appearance,
Yes.
okay. All right, and there's probable cause, and we'll just leave the bond set. $1 million on count 1, 150 on count 2, 100 on count.
Sorry about that, Your Honor.
Pardon?
I lost track. Sorry about that.
Your Honor, For conditions on that case, they would ask that he comply with DCF, as DCF was called because there were children on scene.
Be what, I'm sorry, can you,
They would ask that for conditions on Mr. Grace's case,
okay,
comply with DCF, as there were children on scene and DCF was called,
okay,
as well as no drugs or alcohol without a valid prescription.
all right. Okay.
So you want to order comply with DCF?
Yes.
No drugs or alcohol?
Right. All right, state your name, please.
Rachel Hall.
All right, Ms. Hall, you're here on a capias for failure to appear. On charges of possession of heroin, possession of fentanyl. Bond is set at 0.
Your Honor, in regards to her out on bond, the possession of cocaine, the 21 CF 8556, state would request that you take no action.
I'm sorry?
State would request that you take no action on her out on bond.
Okay. State's position?
That is the state's position.
Okay, no action on that?
Yes, Your Honor.
Okay, all right. So be it. Okay, all right.
Your Honor, DeAndre Holmes bonded.
Okay. All right, state your name, please.
Charles Lamont Johnson, sir.
Mr. Johnson, okay. Let's see. You are on, here for a warrant for, transient sexual offender failure to report every 30 days.
System call.
Says the bond is to be set at initial appearance. Is there a recommendation on the bond?
Yes, Your Honor, state would ask for $5,000 and for you to revoke his out on bond.
All right. Okay, so, yeah, I think that's reasonable in the first count that the,
Just a moment to confer, Your Honor, before setting bond.
okay, I'm sorry, go ahead.
Registered yesterday, going to work yesterday morning.
Your Honor, I wouldn't have you revoke and set at none. I would just have you revoke and set a bond. He was in custody up until, I think, 2 months ago on that 2019 charge. I don't know if you overheard, but he had some issues with his probation officer and it being a day late, and that was what violated it. And so if you would have, he does have a monitor. And so if you are inclined to set a bond in the out of bond case, along with bond in the current charge, I believe that should be sufficient.
State's position?
Your Honor, state would ask that you revoke. Reading the warrant, it appears the allegation is on October 6, 2021. The defendant was last completed his mandatory 30-day transient check-in, and he did not sign his Florida, or his FDLE sexual predator offender transient check-in form. Therefore, the device on his leg was not active. The defendant is stating that this is something to do with probation, so state would ask that you just revoke that, so it can be seen in front of that court and the probation officer, so they can figure this out. However, given his history and given the allegations on why he is on probation, state is concerned regarding the victim's safety as well as the community's.
Again, Your Honor, I believe he has some defenses to that, so I would have you consider that in setting bond as well. If I would understand state's position if the out on bond case was another failure to report, but it is not. He's not repeating offenses, so I would have you consider that.
Your Honor, his out on bond case is also very concerning on conspiracy to traffic and illegal drugs. Bonds on that case were set incredibly high due to the allegations of that case. So he has an out on bond for an extremely dangerous offense. He's a sexual offender, he's on conditional release, and he failed to report, Your Honor. He's shown an inability to comply with court orders. It looks like he was released from DOC recently, as well as multiple VOPs showing an inability to comply with court order, prior failures to appear showing an inability to comply with court order. I believe this would be better seen in front of the trial judge to set bonds and put some additional conditions on Mr. Johnson.
Okay, well, on the new case.
Your Honor, can our client be heard by the court?
Yes.
I understand that everything I'm saying recorded and could be used against me. Just like my attorney just explained to you, sir, I just got a job. I'm trying to work. I went to check in yesterday 3 days earlier to the chill station, and they arrested me for saying I was 1 day late. That what she explained about that case there, sir. I'm not finna speak on that case. I know that case is weak, and I'm trying to get home back to my son and go back to work, and I got things that I got out there I'm trying to take care of. I only been home 2 months. I've been following and doing everything this probation officer and these people asking me to do. Whatever she's speaking on over there, I have no clue. And she talking about multiple violations. That's all in the past. That charge, this sex offender charge is old. 13 more days, sir, it's over with. Because on the 22nd, I'm on CRD. They put the device on my leg for CRD to the 22nd of December. I've been working and doing everything I can. On the December 22nd, that come off. I go to court for that charge on the 14th. That's coming up. And they trying to revoke me as I'm getting out trying to do good. It ain't like I'm out doing bad. I only been out like 64 days. And she trying to seem like I'm a bad guy, and I'm not. They trying to penalize me for something that's happened way back in 2007. We in 21 going to 22? This is a 2007 charge that she's sitting over there penalizing, trying to make me look bad on. And I've been doing what I'm supposed to be doing. I'm sorry, sir, but I'm going to cut it off from right now. I apologize for anything. It's my life.
As I said, $5,000 in the new case.
A lot.
On 2019 CF 1220 12273 I believe. I'm going to stay that one as it is. But he has a.
So you're not going to take any action on it, Your Honor?
Pardon?
You're not going to take any action on it?
Right, no action on that. But does he have is he on it says conditional release on another thing?
Yes, sir.
Yeah, he's on conditional release right now, Your Honor.
On this case?
On which case, Your Honor?
Oh,
So
okay,
that's a different case.
Oh, that's 2019 12273. It says.
No, he's not on conditional release for that, Your Honor. He's out on bond.
On bond?
Bond was endorsed on that case.
And it's a first-degree felony.
All right. Well, I'm going to let those bonds stay in effect. No action. Okay. All Yeah.
He has a condition on the warrant that says to report to the sheriff's office
Yes.
as required by law.
Yeah, right. Okay, you need to report to the sheriff's office or register as required by law.
Sir, I do it every time, sir.
All right.
Every time. I'm on.
Okay, all right.
That's the probation
Okay.
officer's fault that I was on one lady. That was
All
my
right.
fault. This is fine. What am I supposed to do now? So I gotta. What about my other? What about my other? Okay, good. So
Okay. All right, state your name, please.
Ivan Lane.
All right, Mr. Ulrich, is it? Or Joseph?
Lane.
Pardon?
Ivan Lane.
What happened with Mr. Joseph Ulrich?
Is Mr. Ulrich not here?
No.
Refused? Okay, I'll find probable cause and leave the bond at $1,000.
Are you waiving his appearance, Your Honor?
Well,
Yeah.
well,
Is it
PD
waived?
waives the appearance, Your Honor.
Okay. Now, let's see. All right, state your name, please.
Ivan Damaris Lane.
Okay. Mr. Lane, you're charged on a warrant for fleeing or attempting to elude a law enforcement officer. Lights and camera, lights and siren activated. It is on a warrant. The judge says the bond was none until IA, so I guess that would allow an bond. Any recommendation on the bond from the state?
Your Honor, state would ask for $7,500. Upon reading the warrant, it is alleged to have occurred on October 20th of 2021. Law enforcement was doing proactive patrol, was observing the defendant, and allegedly observed him and other people doing hand-to-hand transactions with the vehicle. Law enforcement then approached, and the defendant accelerated at a high rate of speed, maneuvered around the other vehicle, and fled the stop. So state would ask for $7,500.
All right, response?
Your Honor, he's never been employed, and most of his criminal history is nonviolent drug offenses. I would have you consider that in setting a reasonable bond.
All right, I think $1,000 is a reasonable bond in this type of case. I'll set it at $1,000. Pardon? Okay, the condition was,
Hold on.
okay, there's a condition not to operate a motor vehicle. All right. Okay.
Roy Manning.
Yeah, good afternoon. What's your name, sir?
Roy Manning.
Mr. Manning, okay. You're here on a capias for possession of methamphetamine. Failure to appear for trial management conference. All right, it's a zero bond, so set by the court. So I won't disturb that. All right, so if you want to change, you got to apply to the judge that has the case.
I didn't hear that, sir.
Pardon?
I didn't hear that.
Okay, your bond is zero set by the judge that has the case. If you want to try to change that, you must apply to the judge who has the case.
All right.
All right? Okay, good luck. State your name, please.
Chevette Chantel Mitchell.
All right, ma'am, Ms. Mitchum, you're charged with grand theft, third degree. It's on a KPS, I think, is it, or bond? Let's see. Or not, not on a warrant. So.
You're not a standard affidavit, it's just an add-on. So state would ask that you stay her bond at $2,500.
Well, I will find probable cause here. On position, defense on the bond?
Your Honor, she's been employed the last couple months, and a lot of her criminal history is nonviolent theft. I would just have you consider that in setting a reasonable bond, Your Honor.
State's concern is her three prior failures to appear. She recently pled to a petty theft 2 prior. This year, she has several other grand thefts. She has, it looks like at least 3 or 4 other open theft cases. State believes the bond is reasonable as set, Your Honor.
All right, I'm gonna leave it at $2,500.
State would ask for no contact with victims and witnesses and no
Contact,
return to the
no
Ulta.
return. No, yeah, for this, no, it's to the store, whatever. No return to the store. All right, state your name, please.
Tamara Rowe.
All right, Ms. Rowe, let's see.
Your Honor, may I have a moment on this case?
Yes.
This is tomorrow, right? Your Honor,
Sorry?
just some checking on this case. They have all the charges closed out, time served on them.
I'm sorry?
Did she go to court today on it?
Yes, I went to,
Wait.
You went to downtown court?
So have you been to court on this already?
It looks like they time served her on it.
Oh.
Must have seen them today.
Okay, so you went for another judge today?
yes, sir.
Everything's closed out on it.
All right,
Louis F. Calderon.
so the case is resolved?
Yes, sir, it was.
It appears so, Your Honor, yes.
Okay,
second.
all right,
Appears she was time served.
Hold on.
okay, good. All right, she's,
I think the state's checking on it, Your Honor. They just want to double check. Yeah.
That's correct. She pledged supervised probation.
Yeah.
okay, right, all right.
Does she need an order to be released, or she'll just be released?
No, they've already closed the charges. They're already working on her release.
All right. No action. All right. Your name, please?
Name Skipper, sir.
Okay, Mr. Skipper, you're charged with possession of controlled substance, grand theft third degree, and possession of cannabis, petty theft. There is probable cause. State's position on bond.
Your Honor, state would ask that you stay them all as currently set. It appears the possession of controlled substance is the primary, and then each additional count already treated as a subsidiary. State believes that's proper under the circumstances, so state would ask that you stay all 4 bonds.
All right, defense?
Just a reasonable bond amount, Your Honor.
Okay, right now the bond's set for a total of $3,500. Are you able to make that bond?
Maybe, sir.
You are? Okay, so I'll leave him set at that. Okay. All right.
He has 2 cases, Your Honor.
Pardon?
He has a felony as well as a misdemeanor case.
It's what?
He has a second case.
A second case?
Yes, Your Honor.
Yes, 21 CF 15644, which is the controlled substance, the grand theft, and the cannabis, and then 21 MM 8717, which is the petty theft.
Oh, here we go. Okay.
Is that the bike?
I think the bike is the grand theft, then Home Depot is the petty.
Bless you.
So, okay, what is that, the petty theft case, or?
Your Honor, you were speaking about them all as if they're in one case number. It's just in 2 case numbers.
Okay.
The petty theft has its own case numbers.
Okay, that's 2021 MM 8717, is that right?
Yes, Your Honor.
That's correct.
Yeah, okay, that's the probable cause, so that bond would be stayed at $250 in that case.
Your Honor, on both counts, they would ask for no contact with victims or witnesses
Yes,
and no return to the Home Depot.
right, okay, yes. State your name, please.
Robert Smith.
All right, Mr. Smith, you're, oh, let's see. No. I'm just a little confused with what I got here. Let's see. There's no affidavit on this. No. This is a new case? Yeah, this is that new case. Okay. Oh, okay, so, yeah, okay. All right, so I think. so the new case is 2000 or 2021, let's see, 89581, is that right? Pardon? 21 CF 15658.
Yes, that's the new case.
Okay, that's the new case, and that was probable cause for possession, trafficking in hydrocodone, and possession of controlled substance. Gets the bond, standard bond, and that is $1 million for the first count, 150 for the second. What's the state's position on that?
Your Honor, the state would ask that you stay the bonds. I believe those are consistent with the bond schedule.
And then he's got another pending case, possession of oxycodone, possession of cannabis.
Yes, Your Honor, given that they're similar in nature in both drug offenses, state would ask that you revoke it this time.
Response for the defense?
Your Honor, I believe $1 million is too high for our client to bond out. I would understand that out on bond being revoked, but I would have you lower the count one bond condition to a more manageable, reasonable bond.
I thought you said $500,000.
Okay.
Thought he said $1 million.
On the new case, $1 million bond, I'm gonna set that at 500,000 and revoke the bond in the case.
You staying the count on count 2? Staying it at 150?
Yeah, 150. Right, yes.
And you'll appoint the PD, correct?
Pardon?
You'll appoint the PD.
Yes. State your name, please.
Olga Vadi Shabria.
Okay. All right. Looks like you're charged with possession of cocaine and introduction of contraband into county detention facility. You find probable cause. Bonds set at 1,000 on each. Is that the state's recommendation?
Your Honor, state has no objection to you treating one as a subsidiary. So staying the 1,000 on the cocaine and then setting the introducing contraband at 500.
Okay. Your position, the defense?
Your Honor, she's been on Social Security disability for 24 years, has no criminal history, didn't even want to bother her family on this. I would have you set a lower monetary bond.
Okay, all right. All right, with no criminal history, I'm going to set bond at $500 on count one and $100 on count two.
Your Honor, it's two different cases.
Pardon?
It's two different cases, not two counts.
She has what?
It's two cases. One case is the introducing contraband, 15639, and the other is the cocaine, 15636. So it's not two counts, it's two separate cases.
15636 is $500 and 100.
100 on the 15639.
Let's see. What is that charge? Is that this one?
That's the,
Okay, that looked like that was part of this. Oh,
it's two different case numbers.
oh, I see, okay. All right, well, yeah, well, it was still $500 on 15636, and I'm just making $100 on 15639. All right. No conditions, yeah. All right, state your name, please.
Will Vernellis.
Well, you're here on a warrant. Orange County, case 2021 CF 15602. Burglary of a conveyance, possession of burglary tools. The court set bond at $2,500 on count 1, $150 on count 2. And then there's, let's see.
Your Honor, regarding that case, they would ask for the conditions of no contact with victims or witnesses and no return to the scene.
Okay, that'd be granted. And then there was a pending case of 21 CF 15602 for possession of.
I think you just did the 15602, Your Honor.
Beg pardon?
You just did the 15602. There's another new case, 2021 CF 015625 AO.
Okay.
2 counts of attempted burglary of a conveyance.
Oh, okay, I see, that's the new case, okay. Okay, well, that's a warrant on that, yeah. Well, that's the warrant, where the bond is set at $1,000, 100 on count 1, 150 on count 2. Okay.
They would ask for the same conditions, no return and no
Okay.
contact.
Same conditions there, okay. And then there's a pending case. Possession of ammunition, reckless driving, causing damage, carrying concealed firearm. Possession of firearm by convicted felon. We're out on bond on those. 8,000. And fleeing attempt to elude another, that's case 21 CF 15602, right?
No, Your Honor, his
no.
out on bonds.
Okay, that's, okay.
You need
2021 362.
Yes, 326. 326, Your Honor.
Okay, and that's 2021 2974.
Yes.
Okay. Okay. All right, I'm gonna, because of new charges, revoke the bonds on those cases. Okay. All right. So the other bonds remain the same. Is that it? All right. Thank you. Pleasure working with you guys today. Thank you.
Nice to meet you.
Pardon?
Nice to meet you.
Yeah, nice to meet you guys. Thank you. That's good. We're done for the